And I'm pleased to have the opportunity to speak today on the issue of Scotland's compliance with the Aarhus Convention, particularly in relation to access to justice in environmental matters. The committee recently took evidence on this important issue, and I want to take this opportunity to set out some of the key findings and themes that emerged during those discussions. The Aarhus Convention is an international treaty that was ratified by the UK in 2005. It establishes fundamental rights for the public in relation to environmental governance. It guarantees access to environmental information, public participation in environmental decision-making and access to justice in environmental matters. While environmental law is devolved, meaning that the Scottish Government is responsible for compliance in Scotland, the Aarhus Convention's access to justice requirements have not been fully incorporated into domestic law. This means that individuals and organisations in Scotland cannot rely on them directly in our courts. The Compliance Committee of the Aarhus Convention, which monitors adherence to the treaty, has found since 2011 that the UK, and specifically Scotland, has not been compliant with its access to justice provisions. The main issue raised is that it remains prohibitively expensive for individuals, community groups and NGOs to bring legal challenges against environmental decisions in Scotland. The evidence we heard during our recent session reinforced this point quite clearly. The Aarhus Convention Compliance Committee has repeatedly found Scotland in non-compliance regarding access to justice in environmental matters. And I'll be keen to hear from the Minister in this debate on what specific steps the Scottish Government is taking to address these findings. A striking example provided to the Committee of barriers to environmental justice was the John Muir's Trust judicial review challenge against the Stronlairg wind farm. The Trust was ultimately unsuccessful in its case, but the financial consequences of pursuing the challenge were severe. The Scottish Government and the energy company, Scottish and Southern Energy Networks, sought legal costs of £539,000 from the Trust. While this was later negotiated down to £125,000, such sums are still a significant sum of money and pose a substantial barrier to justice. For most organisations, and certainly for members of the public, these costs are simply unaffordable. The reality is that the financial risks involved in environmental litigation deter many people from bringing cases at all. This raises serious concerns about access to justice and compliance with Aarhus requirements. The evidence heard by the committee suggested three key potential solutions to address these concerns. The first is to repeal the joint interest test in legal aid for environmental cases. At present, this test makes it extremely difficult for individuals to obtain legal aid for environmental matters, and community groups or NGOs are not eligible at all. The second potential reform is the introduction of qualified one-way costs shifting in environmental cases. This is already in place for personal injury cases in Scotland and would mean that individuals and organisations taking environmental cases would not be exposed to the risk of paying the other party's legal costs if they lose. The third proposal is the establishment of a specialist environmental court, as exists in many other countries, to provide a more accessible forum for environmental cases. Regulation 15 of the Civil Legal Aid Scotland Regulations 2002 has been cited as a barrier to obtaining legal aid for environmental cases. I'd be keen to hear from the Minister if the Government is planning on reviewing or amending this regulation to broaden the scope of legal aid and improve access to legal aid in environmental matters. Another key point raised during the session was the availability of legal representation. Even when individuals or organisations are willing to pursue environmental litigation, they often struggled to find a solicitor to take on their case. The specialist nature of environmental law, combined with the relatively small number of practitioners in Scotland who focuses in this area, creates significant difficulties. In some circumstances, potential claimants are unable to secure legal representation at all. This renders access to justice effectively impossible. The barriers faced by community groups were also highlighted during our evidence session. Unlike developers who have the time, financial resources and the expertise to navigate complex planning and environmental processes, communities often find themselves at a disadvantage. Many groups lack the technical knowledge required to engage effectively with environmental decision-making at an early stage. Witnesses stress that meaningful public participation is a fundamental principle of the Aarhus Convention, yet many people feel disenfranchised by the system. Community groups often face challenges in engaging with complex planning and environmental processes, and I hope the Minister can share with us how the Scottish Government can support these groups in participating effectively in environmental decision-making.